Article 9, Section 5, known as the Blaine Amendment, is a relic of religious bigotry that prohibits funds, state funds, I should say, from flowing to sectarian organizations.
That is Senator Brian Lenny from Nampa, Republican Senator Brian Lenny from Nampa, talking about the Blaine Amendment in Idaho. And that is what basically it is something that's been in our Constitution, well, for a long time, since the 1890s. And this is what it says. It says basically sectarian appropriations prohibited. Like the state cannot get any money, cannot put any money, anything in aid of any church or sectarian or religious society, or to help support or sustain any school that is controlled by any church, sectarian, or religious denomination whatsoever. So there have been a couple of rulings lately that he said making it null and void. But the question is, has it rendered it null and void, which is what Senator Lenny is saying? Has these rulings from the U.S. Supreme Court ruled the Blaine Amendment null and void? The question, we asked this of a former attorney general, basically said, okay, so hold on. It's not necessarily null and void, Joe, because what the the U.S. Supreme Court said is they have not said the Blaine amendments in these other states, especially when it comes to like Montana versus Espinoza versus Montana Department of Revenue. That's a Supreme Court ruling that said it's not unconstitutional, but if you're going to give money to a private institution, a private school, well, you cannot not give it to a private religious school. So basically that whole freedom of expression clause that's in our Constitution. That's what the delineation is here. So for him to say this is a dead letter in the U.S., or excuse me, the Idaho Constitution, I think some would argue that, and that may very well be where some of these education savings account opponents have a fight.
Right, because the clarification is made here that if you are going to give money to private schools, then that's a whole different conversation. But if you come to the conclusion here in Idaho that says, okay, we're going to let public dollars go into private schools, what the Blaine Amendment here would say, well, hold on a second, they can only go to private schools, not secular schools. Or excuse me, they can only go to private schools, not religious schools. But what that Supreme Court ruling then clarifies is if you're going to give any money to private schools, public money like this, you can't discount, you can't, box them out if they're a religious school.
And getting rid of this, I think, then also opens up the door that, okay, we can give money to anyone. Then you get rid of that clause, that part of the Constitution that says you can't give anything to any religious sectarian group or whatever. And that would open, I guess, a can of worms possibly for that.
Yeah, so I mean, we're watching, the steps being taken, incrementally at the State House, the ESAs, the vouchers, if you want to call them that. This is a big portion of that we'll be watching.
And the question is, can you have both? Former Attorney General David Leroy says, yes, you can have both, the Blaine Amendment and education savings account. We'll see how it plays out.